may begin now.
Good afternoon all. I welcome you all for today's digital guest lecture by Advocate Mrunalini Deshmukh. Myself, Advocate Suchita Butda, member of Sangli Bar Association, and I am here to introduce Advocate Vasantrao Patil, Lawyer Training Center established by Sangli Bar Association with great effort of all senior and junior members of Bar. This unique center has been established in the name of Advocate Vasantrao Patil, who was one of the best criminal lawyers of his time. He also served as president of our bar. During his tenure, he had taken initiative to arrange conferences by involving foreign lawyers and also conducted many fruitful activities for betterment of the Sangli Bar Association. He brought glory to our bar association. Our Sangli Bar has a history of taking up initiatives for such activities, and our bar members always cooperate and support. The purpose of this platform is to boost the confidence of aspiring as well as practicing lawyers. Our motto is to impart knowledge, to inculcate discipline and overall development of personality of practitioners. I am sure that with support of our bar association, we'll definitely achieve our aim of betterment of legal fraternity. Thank you so much, Deshmukh ma'am, for joining today. Now over to Advocate Priyanka Rane Patil ma'am.
Thank you, Advocate Suchita. Mrunalini Deshmukh ma'am has graduated in economics and has done her master's in law. Ma'am is an alumni of St. Xavier's College, Mumbai and the Government Law College, Mumbai. She holds an LLM from the University of Mumbai in commercial law and matrimonial law. In the past, ma'am has been a professor of constitutional law at the KC Law College, Mumbai, and taught postgraduate students as a visiting faculty at the Department of Law, Mumbai University. Ma'am often practices and has addressed domestic and international conferences on issues relating to family law and structuring of wealth and alimony issues, especially the laws governing women. Ma'am strongly believes in gender justice and is extremely sensitive about injustice and malpractices which actively propagating the gender equality. She recently addressed an international conference on wealth planning for global Indian families in Dubai, UAE. Ma'am has authored a book on divorce, Breaking Up Your Step-by-Step Guide to Getting Divorced, published by Penguin Publications. Ma'am has also dealt with cross-border cases relating to marriage, validity of foreign courts, applicability of Indian laws of marriage and their effect, cross-border child custody cases, effect and enforcement of foreign court orders, validity and enforcement of Indian laws on child custody with special reference to foreign court orders. Ma'am has appeared and argued all the above in the trial courts as well as the Supreme Court of India. Ma'am has been invited to give legal opinion in foreign courts and has been examined as an expert witness and given opinion on the applicability or otherwise of the Indian Marriage Act, especially the Hindu Marriage Act 1955. A few of them to mention: 2007 to 2008 Boston Court, 2015-2016 New York Court, 2018-2019 the Tampa Court, Florida, USA. She has given her expert legal opinion in the courts of Dubai, UAE. Ma'am has addressed the Columbia University, USA students at South Asian Millennial Conference on Sexual and Domestic Violence in South Asia in February 2016, and in June 2016 addressed the international lawyers in juries from countries like USA, UK, Australia, and other Asian countries on the ethics and values of legal practice. For many, Deshmukh ma'am is a celebrity lawyer, but to me, she's a lawyer who is a celebrity. Mrunalini Deshmukh ma'am is the name that accompanies headline-making divorces in this country, be it the Amir Khan Reena Datta case, the Karishma Kapoor case, Hrithik Roshan Suzanne case, Mahesh Bhupati, Riya Pillai, Aditya Chopra, or Karan Johar surrogacy case. The list is endless. Ma'am bears many name tags. Tigress is the famous of all. In the courtroom, She is known to shred her opponents to pieces by her legal knowledge and arguments. But in person, she is the warm, affectionate lady whose smile is infectious. Whenever I see ma'am, I'm reminded of the famous lines. Ma'am is a woman of strength, courage, and dignity, one who values herself and fights for what she believes in. And that is what makes her beautiful inside and out. Thank you so much, ma'am, for joining us. It's our privilege, what we call today as the Pink Webinar. Welcome you, ma'am, and over to you.
Thank you so much. I'm so overwhelmed by the warmth and the kind words that all of you have said about me. I really, really hope that I live up to the expectations that you all have from me. I think I'm extremely fortunate that the training center considered me to be, one of the speakers to address the lawyers. And as I've just informed, more of the lawyers which are basically from the district and taluka levels, who at times may or may not have access to the best of the legal grades or the laws that are being argued at a little higher level. I think this training center's work in this field of empowering and educating the lawyers or the people from our legal fraternity to become knowledgeable, wise lawyers. I think it's a great job that is being done by them, and I would like to congratulate them. And I think they should continue this this good work that they have taken up upon themselves, because they are not only doing justice to the lawyers, they're doing justice to the society. In fact, the importance, as we are just talking, in fact, there was a sort of a seminar which was addressed by the Lordship Justice Chandrachud of the Supreme Court, where, as you all know, that he's in charge of the e-courts and how to have this functioning of the courts, virtual courts in these pandemic and the situation that we are in. And I can just tell you that what he has said about the lawyers, he has said that these lawyers are the backbone of the judicial system. And he said that it is extremely important for the highest judiciary to create an infrastructure and to create such a situation which will help them learn, absorb, and also adapt to these changing times, because this is something that all of us are new to, and some of them may not have access to it, and probably centers like this provide them a medium to do so. So having said this, I thank the organizers once again, and they have given me to speak on the subjects of alimony and child custody. Mind you, both these subjects or both these topics are very exhaustive. They have a lot of nuances. They have a lot of sort of, wheels within wheels to understand what the whole thing is. So I will try and complete as much as I can in these two topics, which is there. But something, and I was just informed whilst this introduction was there, that today is known as the Parents' Day. And what better subject than the child custody issue in cases of children who are locked in the custody battles than today's date to address these issues and what has been the legal view on cases of custody which is there. So at in the beginning, I'd like to talk about the alimony part of it. Now, what is alimony? If you ask me, do you find the word alimony in any of these statutes and things like that? The question here is that we have to understand maintenance and alimony. Maintenance and alimony are part of the same process, but they are divided at two different junctions. Maintenance could be maintenance pending the petition, which is the maintenance pendente lite as we call it, or it could be something which is called a permanent maintenance. And alimony is something which is associated when a couple decouples, as they call it, or as the couple gets divorced by the court. It's a mark of respect to the woman, in most of the cases, where she is granted some alimony for her sustenance and for her to be able to lead a comfortable lifestyle, which is there. So this is the basic concept that we find as far as the alimony and this. One more thing that I would like to bring also to the notice is one of the essential things in maintenance and alimony is the issue of a marital home, or is the issue of a matrimonial home, as we call it. We do not have a concept, and when I say we, I mean the Indian law. We do not have a concept of a matrimonial home per se within the provisions of the law. However, this is a term that has been absorbed and adopted by us from the English Matrimonial Causes Act, where the term of matrimonial home was there. Overseas, as you are aware of, a matrimonial home is a home where the husband and the wife reside. And most of the times it is either owned by them singly, jointly, or it is rented out by them singly, jointly, as the case may be. What is peculiar to India with regards to the matrimonial home is that when a girl gets married into the house and she knows that she is going to stay in such a particular place, most of the time the girl and her parents are not aware as to in whose name the house stands. And that is where the problem begins if there is an issue of, alimony, divorce, and the matrimonial home to each other. So there has been a lot of case law which has been developed on this, which I shall also be dealing with. So to begin with, I would like to say that under the existing laws that we have, and we have many laws, and I would say there are many interpretations of that law also. The concept of maintenance was available also pre-codification of the law. The pre-codification is prior to 1955, when the laws were not codified, when the Hindu law was not a codified law. Even then, that had the provision of maintenance for the women, for the children, and for the widow in case of such situations which were there. This concept, which is from the pre-codification, has now been incorporated in the statutes in the several forms that we are going to see right now. So when I talk about it, I'll just give you a gamut of what are the sections that I'm going, and please bear in mind, I'm not going to be giving you a lecture like you have in a law school, but I'm going to just give you the main provisions of what is there. So we all know that the marriage laws are personal laws. We are all governed by our personal laws. So we have personal laws where you have a Hindu, then you have a Hindu Marriage Act, you're a Christian, you have the Christian Marriage and the Divorce, Indian Divorce Act, Parsi, so on and so forth. So every act itself has provisions regarding the maintenance. We also have a secular provision, which is irrespective of your religion, irrespective of where you belong to, the law, that particular enactment or the laws are applicable to you. Let's call them secular laws. And those secular laws are Section 125 CR, Criminal Procedure Code, where it is applicable to any woman, any wife, which is there, irrespective of her religion. We also have something like a new provision under 2005, the Protection of Women from the Domestic Violence Act, which also has inbuilt provisions of maintenance and monetary compensation in the event the lady or the aggrieved person has been able to prove her that she has been in a domestic, there's been domestic abuse and domestic violence on her, and she needs compensation for that. So now, if you go under the Hindu Marriage Act, and I'm just taking that as a sample example, which is there. Under the Hindu Marriage Act, you have Section 24 and you have Section 25. Just let's deal with it for the time being so that we don't go all over. Section 24 says that pending the petition, whichever petition has been filed, whether it's filed with the husband or the wife, it could be for divorce, it could be for judicial separation, it could also be for restitution of conjugal rights. Whichever petition is pending, if in that proceedings, one of the spouses is unable to support himself or herself, then he or she can approach the court and make a case that I am the legally married person, I am unable to support myself, and I need X amount of maintenance from that. So what is the special feature of this? That this law is gender neutral, which means it could be either the husband or the wife who, in a given case, could approach the court. And if the courts are satisfied, even to the extent if the courts are satisfied that the husband is unable to support himself and the wife should support him because she's an earning person or she has got ability and capacity to earn and has sufficient funds of her own, then the courts can order that. So I think this is a very unique provision. This provision is also found under the Parsi Marriage and Divorce Act, where either of the couple, either of the parties, which is either the husband or the wife, could approach the court. This is applicable not only under Section 24 of the Hindu Marriage Act, it is also applicable under Section 25, which deals with the alimony. Now, before I get into what are the factors that are considered, an interesting question that came up, that let's say in a given case, a wife leaves the husband and she starts staying elsewhere. He calls her, come back, let's resume cohabitation, let's live together. For some reason, she doesn't come. Then he files in the court what is known as a petition for restitution of conjugal rights, asking the court that honorable court may direct my wife to come and reside with him. Now this, as you know, the restitution petition will have to be tested by the court, that where she was justified from withdrawing from the society of the husband, or whether she's done that in an unjust, unfair manner, whether the husband has made efforts to keep her happy, and so on and so forth. Now, sometimes the question comes up that in such a situation, let's call her the deserted wife, and I'm coming to desertion is a different under the law, but I'll come to that a little later. If a deserted wife is there, and if a husband asks for restitution of conjugal rights, can she claim maintenance in that? Because is it that she is taking advantage of her own wrong? Is it that she is just trying to not go back and live with the husband? At the same time, she doesn't want to do her conjugal duty. She does not want to fulfill her obligations which are there, but she wants to have maintenance and lead her life independently. Whether such a woman should be given, and I'm just taking woman because this is the case that I'm giving you, whether such a woman should be given maintenance under the restitution of conjugal rights. This was a case that will come up, and the courts have held that till such time that the courts arrive at a decision, going through the facts of the case, the merit, the laws which are applicable, that whether the case of a husband in the case that I've given you is a justified case, that the wife has left him without a reasonable cause and abandoning her matrimonial duties which is there, and then at the end of it, the courts may direct her that, listen, you have done all these things, you better go and join back your husband and start residing with him and resume your matrimonial cohabitation, because that's what marriage entails. And these are your responsibilities and obligations. But till such time that the court decides, in the interim, the courts can pass maintenance orders in favor of the wife. This is as far as the restitution of conjugal rights is concerned. And similarly for the other provisions is also there. Now the question that arises is, how does a court arrive at a number? Whether it's going to be 100 rupees, it's going to be 1,000 rupees, it's going to be 1 lakh per month, it's going to be 10 lakhs per month, how does it occur? So the procedure that, and I'm sure that since there are lawyers, all of them know, maybe I'm just repeating myself and it may not be something new for them, is that when an application is made by the person, and again, I'm just taking for the sake of argument, a wife has made an application seeking maintenance from her husband. Then in that application, she has to make pleadings, or her averments will have to be that A, she has no income, or remember that she has no sufficient income to maintain herself, and maintain herself how? In the same style, in the same status as which they lived as husband and wife during the period of that cohabitation. So for lawyers, I may just give you a word of advice that if a person comes to you, and let's say for the sake of argument, a lady comes to you and says that I have no maintenance, I have no money, and I want you to meet this. It is the primary duty of the lawyer to first examine his own client and get the facts very clearly, whether she has no income or whether she does not have sufficient income in comparison to the husband's income. Because tomorrow, you do not want to make any pleading which amounts to perjury if there is knowledge about the fact. Yes, perjury is for the litigant, not for the lawyer, but it is the bounden duty of the lawyer to guide the client in this case, to say that you have to come out honestly to me as a lawyer. It's a privileged communication between you and me as a client and a lawyer. You have to come out honestly, and then I will do my own study. I will see what according to you is the income of the husband, and accordingly I'll do the pleadings which are there. So the wife and the applicant, let me call the applicant. The applicant has to say that he or she does not have sufficient income of her own. Also has to say that the husband has XYZ as the income, And that is why she is entitled under Section 24, pending the petition and final disposal, a sum of rupees X towards her maintenance. Now, if you ask me, where is the word maintenance mentioned in the Hindu Marriage Act? There's no definition of maintenance. So then we go back to the Hindu Adoption and Maintenance Act, in which in Section 3, the word maintenance has been defined. And it means provision for food, clothing, residence, education. Let's go one by one. It means for food, clothing, residence, education, medical attendance, and treatment. So these include not only the living expenses, but in certain cases, they also include the education expenses and the medical expenses of the person concerned. So this is the way. Also, the word residence has been mentioned as a part of maintenance. So if you do not find the word residence, matrimonial home, marital home in the Hindu Marriage Act, you should not wonder, how can I go and ask the courts to give me rights of residence when there is no such provision? So you have to go back to the Hindu Adoption Maintenance Act to understand what maintenance includes and means in this case that we are talking about. Now, when we are going to ask about maintenance, how is the court going to decide the amount of maintenance? It is going to decide on the following factors, which again you find under Section 23 of the Hindu Adoption Maintenance Act, and which says the position and the status of the parties, to the reasonable wants of the claimant. I'll explain everything. I'll just read out first. If the claimant is living separately, whether the claimant is justified, that also I'll explain. The value of the claimant's property, income derived from such property earnings, and the number of persons entitled to be maintained. So if you just analyze this, how the courts will have to do, because tomorrow some of you are lawyers, they are going to be judges also, whether they're going to be trial court judges or high court judges, Supreme Court judges. You will have to know that how do I decide what is a proper maintenance, what is an amount which is just and fair to be given to the applicant which is there. So it says position and status of the party. So obviously this is a very relative term. What is the position of one couple vis-a-vis the position of the other couple, their background, their financial thing, whether they are professionals, whether they are working with service people getting an X salary which is there, or whether they belong to the business community, or they belong to the community of the industrialists and the affluent people where their lifestyle is. So their position and status is one of the considerations that have to be seen. Now, I have seen in my experience and that at the time of marriage, and this I'm sure you also as lawyers must have seen in the cases that have come to you, at the time of marriage, very exaggerated and very fantastic numbers are given about the husband being a part of the business, earning lakhs of rupees, having a great lifestyle, having so many cars, etc., etc. And when the matters go to the court, and even the courts have held this, that they all of a sudden become very pauper, they have no money of their own, and they themselves are sort of, some of them are surviving on the dole given by their parents or other people which are there. So under such circumstances, how does the court decide? Because if the court has to decide that the document is showing that he is earning only, say, 20 lakhs per year, but his lifestyle is that of somebody earning a crore per year. So how does he justify this? So this is the position and the status the courts will have to consider, even if the income document before the court is showing a much lesser amount. So this is what is meant. Now, reasonable wants of a claimant. Now, this is a very important thing, and I think you should now, as lawyers, keep that in mind. Clients come to you expecting the moon and the stars from their husband. Either it is to get back at him because of what has happened, and to pinch him monetarily so that he suffers, or to have a great lifestyle living separately at the cost of the husband. So you as a lawyer will have to analyze and sit down what could be a reasonable claim of maintenance by your client who is going to apply to the court. So this is a study that you have to do. So please understand that the application under Section 24, I'll come to 25 later, an application under Section 24 cannot be just done it in a template form. And yes, source of income, no source of sufficient, not sufficient. It has to be made out, not the allegation regarding what the interpersonal relationship, but surely about what the incomes are, what the lifestyle is, and what the things are. The third one is if the claimant is living separately, whether the claimant is justified. Most of this does not come at the interim stage level, because obviously the courts are going to say that the parties have to still prove their case, whether the claimant is justified or not justified. Under the Hindu Adoption Maintenance Act, as you are aware of, that Hindu woman is entitled, under Section 18, a Hindu woman is entitled to live separately from her husband without forfeiting her claims of maintenance and XYZ if she's been sort of treated in a cruel manner, deserted, he's been adulterous, etc., whatever those things are there. So these are the clauses that justify a woman not to live with her husband, live separately, and claim for that. Under such circumstances, the courts consider whether the claimant is genuinely living separately for genuine reasons and not for any other reason. Please understand, the law has to be fair. The law has to be balanced. So though we find that the courts, the legislation, and all of us are having a lot of laws which are favoring the women and children, at the same time, as a judge, before the judge, there's no man, there's no woman. Before the judge, there's only equality. So this is important. Then the value of the claimant's property or the income derived from such property. So the value of the property is computed at the time of the final divorce, final alimony after the divorce. And the income from the property is computed at the time of the interim maintenance, which is there. So when you are arguing a Section 24 application before the court, and I've just taken this as a model one, then you will not have to say that he's got property, say, which is worth 10 crores. You will have to say that from his property, which is worth 10 crores, the income that he arrives from these properties is, say, 5 lakhs per month, example. And that should be considered by the courts, his income from the properties, in addition to whatever other sources of income are, to be considered by the courts at the time of deciding what should be the quantum of maintenance to be awarded to the wife. And lastly, number of persons entitled to be maintained. As we all know, that it is the bounden duty of the husband or the father to maintain his wife and his children in the same standard of living that he has. But there could be also cases where he is also bound to maintain, say, maybe his old parents, maybe an old aunt or somebody who's living with him right from the time before the marriage, which is there, and it is his duty and which he has been doing. So the courts are not going to say that, no, you discard all those things and just look after the wife. They will consider the fact that this man is also obliged to maintain, say, maybe his parents or an old grandmother or an old aunt who's been living with him, because he cannot just discard them to be able to give the wife the sufficient. So these are the parameters which are there. So what has really happened is that the scope of maintenance, about the quantum of maintenance, how to arrive all these things, are not found exactly in the body of the section, but has been expanded, has been sort of interpreted in a very justifiable manner by the honorable courts, high courts, and the Supreme Court of India, to be able to be a law or the interpretation of that section to be able to be just, to be fair, and to be equitable in that sense of the word. So the courts, when passing orders, are going to see whether the order, after considering all the factors which I've just showed to you, whether the order is fair, whether it is equitable, and whether it is just. It cannot be unjust enrichment of one spouse at the cost of other, because that's not the intent either of the legislation or the judiciary. At the same time, it cannot be that a pathetic order is given, which is absolutely to the disadvantage of the woman or the children in a given situation. So which is just, it becomes more like some breadcrumbs which are thrown to her, and not really a respectable sum for her to be able to live with dignity and with the same standard of living as the husband is also there. So Section 24, one of the cases, and I'm sure you're all lawyers, so you know about it. Maybe it's a repetition. But Jasbir Kaur Sehgal versus the District Judge Dehradun, 1997, 7 Supreme Court cases 7. Here, this judgment was given by one of the finest judges, lady judges of the Supreme Court, Justice Sujata Manohar and Justice Badwa, in which they have held, and permit me to read, that no set formula can be laid down for fixing the amount of maintenance. It has, in the very nature of the things, to depend on the facts and circumstances of each case. Such scope for leverage can, however, be always there. The courts have to consider the status of the parties, 1. 2, the respective needs of the parties. Number 3, the capacity of the husband to pay, having regard to the reasonable expenses for his own maintenance and those he is obliged under the law, statutory but involuntary payments and deductions. Which means, if you've been paying the EMIs for the house, or if you have been paying, you have to pay the income tax. So obviously, these are the statutory deductions which are there. So all these things are considered by the court when they do that. Secondly, they have said that the amount of maintenance fixed for the wife should be such that she can live in a reasonable comfort, considering her status, mode of life she was used to when she lived with her husband, and also that she does not feel handicapped in the prosecution of her case. So, which means Section 24 also has a provision for litigation costs, even at an interim stage. This is all to strengthen the woman, or which is in most cases, but a spouse under the Hindu Marriage Act, to be able to prosecute the case in a proper manner and not to be deprived of having access to the courts because he or she does not have the finances to approach the courts which are there. Now, these are the cases which I'm just taking one each case because otherwise we will not be able to complete what we are supposed to do that. Now, we go right from the 1997, let me come back to 2017. So we all know this judgment of Justice Bhanumati, the ladyship just retired, I think, last week. And she has, in Kalyan Dev Chaudhary versus Rita Nandi, she has said, and this was a judgment given under Section 25, and she had analyzed Section 25, and then the Honorable Judge has said, and they referred to the earlier judgment in Kulbhushan Kumar versus Rajkumari, 1973 SCC 129. So this judgment of Kalyan Dev referred to the earlier judgment of the Supreme Court, and where it held that the Supreme Court has held that 25% of the husband's net salary would be just and proper to be awarded as maintenance to the wife. Further, the alimony should be befitting the status of the parties and the capacity of the spouse to pay the maintenance. Maintenance is always dependent on factual situation of the case, and the court would be justified in molding the claim of maintenance passed on various factors. So I have given you one case law where how would the courts determine an interim maintenance, and how would the courts determine this? But now let me come to the difficulties that you and I as lawyers face in the court. I am making a claim that my client's husband is earning 5 lakhs rupees a month. He comes and he says that, no, I'm not earning 5 lakhs rupees a month, and this is all, I'm barely making 1 lakh a month, and I'm not able to do that. Now, how do I get his document? So there is a provision under the CPC, as we all know, for the production and inspection of the document, where you under Order 11 can ask the husband to produce all his income related documents, first by giving a notice. If he does it, well and good. If he doesn't do it, then seeking orders from the court. Because again, the courts may come to what they may feel as an adverse inference, or they may come to a number which probably could be a just and fair based on the pleadings which are there. But actually what speaks are the numbers which are there. So that is the reason the courts can compel the non-applicant to produce his or her income documents to be able to, so that the court is able to arrive at a just figure. Now, it is not only that the non-applicant has to do it, even the applicant has to do it in cases where the applicant is a working person. For example, if the person is a working person, but she says that I'm earning 50,000 per month, my husband is earning 5 lakhs per month, and I'm not able to have the same standard of living because of the huge difference in our income which is there. So to be able to justify that I am earning 50,000, I have to produce the document. So it is also incumbent upon the applicant to produce income documents to the court, to be honest to the court, and to disclose everything which is there. Because always remember one thing, the courts reward honesty and come heavily upon dishonesty or non-disclosure or concealment of certain things which are there. So if you follow this principle, initially if you do it, you may gain some advantage, but in the long run, it will not be there. So it is extremely important for lawyers who are appearing in these matters to do that. Lastly, how would you say the status and the lifestyle? What happens is in most cases, the lifestyle that the couple has led during the period of their cohabitation has been a pretty lavish lifestyle. Probably they've had foreign holidays, they've had fine dining, they have purchased a lot of jewelry, and a very lavish lifestyle. However, the income, which I started my talk and I said that, however, the income documents are not showing that kind of income that the husband has. In such cases, the courts are going to arrive at a figure which they feel is just and appropriate, considering not only the document, but also the lifestyle and the status of the parties, to be able to be fair to the applicant, that he or she gets, in a way, a just and a fair amount of maintenance which is there. The question that normally comes up is, and I think that must be the question in the minds of quite a few of the lawyers who are here, that is a working woman entitled for maintenance? Because maintenance is for someone who is unable to support. So can you do that? So the answer to that question is that yes, working women are entitled for maintenance. However, they have to justify and they have to be clean and honest to the court and tell them this is what their income is. They have to justify their expenses, what they are. If there's a minor child or children which are there, the expenses, reasonable expenses of the children, and then come and tell the court that this is what I'm earning. And that is why I started by saying you have to take a very honest sort of confession from your client as to exactly what it is. It should not be a surprise for you as a lawyer in a court of law if the husband's lawyer produces some income document to show that your client has got so much of money or so much of property or income arriving out of this property and she has not disclosed it. So obviously the working women can get, if there is a remarkable difference in the income of the husband and the income of the wife also in certain cases which are there, and vice versa if the husband is the applicant or not. We also come across cases where we understand that there are highly qualified women, professionally qualified women, and I have dealt with a lot of those cases and I can share them with you. Professionally qualified women who, because of the dispute with their husbands or whatever it is, just don't want to work, don't want to earn anything. And they just want to sit and, okay, I'm a wife. Yes, I may be a lawyer, I may be a doctor, I may be doing any of these things. In fact, one of the matters that I'm doing, the wife is I'm representing the husband. The wife is a highly qualified dental surgeon. They had lived in the US for quite some time and she'd done an advanced course in dental surgery in the US. And then after, because the change of job, etc., they came back here and the husband filed for divorce. Immediately she filed for maintenance. Now she is a highly qualified person, but because, this is my contention, I don't know, but because she wanted her husband to pay her more and she didn't want to do either because she was lazy or because she wanted to punish her husband, whatever the case may be, she took up an assignment of dentals, or that called being a dentist or a dental surgeon, in one of those charitable organizations which are there. Okay, nothing wrong in working for a charitable organization or any institution which is there. But when you are coming to a court of law and saying that I'm unable to maintain myself and I need sufficient amount from the husband to maintain the same lifestyle, somewhere the courts are going to consider that why is it that you're not working? You will see in the US, and since I've done a few cases, I can share this with you. A wife cannot come and say that I'm just staying at home and my husband should maintain me because of the divorce which is there, unless the courts there look into the fact, which is the age of the person. Suppose there's a lady who is above 60 or 65. Look at the medical condition of the person. Okay. Look at what the other circumstances in terms of what could be, suppose if you have children and you need to be personally looking after the children. So these are your disabilities which are because of the circumstances around you. And then, yes, you're highly qualified, but you're not working. But would the courts consider giving maintenance to such women who are highly qualified? In my case, which I'm talking about, there is a child who's around 23, 24, who is studying overseas. The father is taking care of everything which is there. So, though there is no rigid formula, the courts consider in some of the cases that even if a woman is qualified and even if a woman is professionally was professionally engaged in some activities, they may be a lawyer, doctor, whatever, IT professional, prior to these things which are there. If today she is unable to do so, some of the courts have taken the view the law should favor the woman and should be given there. My personal view as a lawyer practicing in this is we do not want to give undeserving people, but we want to go all out and give the deserving people. But this is the courts. We have to abide by the orders of the court. But these are the points that overseas also, you cannot just get away with saying that I have no income and I'm just going to sit at home and I'm going to be where I am and you have to take care of it. It's not going to happen. So that's one point that we have to bear in mind. So we have this case of whether a woman who is working is entitled to be given alimony, etc. So the case is the Vinny Parmar versus Paramveer Parmar, 2011-13 Supreme Court cases 112, where this judgment was given by their Lordship Justice Satasevam and Justice B.S. Chauhan. They had relied on this, when they passed this judgment, they had relied upon the earlier judgment of the Supreme Court in Bhagwati Dutt versus Kamla Devi, which was 1975, 2 Supreme Court cases 356. And what they have held, in both the judgments, I'm giving you the gist of it, that the object of these provisions is to prevent vagrancy and destitution. And the court has to find out as to what is required by the wife to maintain a standard of living which is neither luxurious nor penurious of the wife, for such moderate living can be family determined only if her separate income is considered along with the joint income of the husband. So this is in brief what I thought is something that I've been able to explain what is maintenance and what are the views of the court as far as this is concerned. Now the real struggle starts is about the residence part of it. In some of the cases, the courts, even at an interim stage, do grant some amount of maintenance some amount as towards the residence of the wife or the child is concerned. So maybe it could be a rental thing or it could be any other stuff which is there. And the final analysis also, the courts would consider that if a woman has spent a substantial 20, 25 years of her life in this house, she's lived in a particular house, which may not be classically in the name of her husband, but maybe her in-laws. But she's lived with, for whom that was a home. And today, even if the husband has sufficient money, he said, this is not my home, you cannot stay here. The courts have considered that the duration of the marriage, the number of years invested by the lady in the marriage, the lifestyle that she enjoyed during the, say, example, 25 years of their married life, and also the income of the husband will have to be considered to be able to provide residence for her after the divorce is granted after 25 years. So this is what the courts have taken into consideration. A new concept which has been introduced in law is that of the shared household. Now, what happens is, what is a right of a woman in a house which belongs to her in-laws? Let's come to the DV a little later. Shared household, as we all know, is a part of the domestic violence provision, provision which is there under the Domestic Violence Act. But in a case, if you don't have domestic violence, what are the rights of the wife? And this is what I have said, that though a wife cannot claim the in-laws house or a share in the in-laws house to be her house, because it does not stand in the name of the husband and it stands only in the name of the in-laws, the courts compensate the lack of it for the in-laws by taxing by asking the husband to pay this amount which is there. Because we have to understand one thing, that these orders are in personam, that is against the, let's say, respondent or a non-applicant in this case which is there. And you cannot drag into this entire situation the income of the in-laws, for example, the wealth, their assets, and the lifestyle that they have. Because the law considers that it is a unit of a husband, wife, children, which has to be considered to be together. Yes, it's a unique feature of the Indian law, Indian social structure, where most of us live with our in-laws from the time we get married till such time that things, the way things are. And all of a sudden it becomes, oh, this is not your house, it is the in-laws' house. But the court says that the status of the husband or the wife in the house of the in-laws is that of a gratuitous licensee and not that of an owner. So as you understand what is a gratuitous licensee, as if you are a licensee, sorry, may I have some water? As if you are a licensee, but you are not paying the rent because they're your in-laws or because they're your parents and things which are there. A right can only be claimed against the husband and his income, his assets, etc., but not from what otherwise the people around him is there. So the difficulty that a woman faces is that she has led a lifestyle, say a very comfortable and luxurious lifestyle, maybe because of the in-laws. And when things were fine, everything was common, everything was joined. We all went for holidays, we all did everything there. And all of a sudden this divide happens and no, this is not yours and this is. This is where the woman is also caught into a kind of, she's not aware of what her situation is. And that is why the law is very clear. Now I'm coming to another concept of residence, which is the shared household. Now, as you're aware that, and I'm coming now to domestic violence, as you're aware that under the Act, Protection of Women under the Domestic Violence Act of 2005, for the first time, there are certain 2-3 concepts which are there. And I think we need to understand that and analyze the definition before we go into the provision. And you will permit me to read certain new concepts which have come up. So under the DV Act, sorry, there is what is known as a domestic relation, which is under Section 2, subclause F for France. Domestic relationship means a relationship between two persons who live or have at any point of time live together in a shared household when they are related by consanguinity, that is blood, marriage, or through a relationship in the nature of marriage, adoption, or of family members living together as a joint family. So this is a wide scope. But let's limit ourselves to the main ingredients of this, which concern our discussion today. Means a relationship between two persons who live or have lived at any point of time together in a shared household. So I may live with my husband in a household where my in-laws are also there. And that's a shared household because we all lived. It does not talk about the ownership. It talks about a shared household. So the shared household is there. And when they're related by marriage or through a relationship in the nature of marriage. Now let's pause here for a moment. Relationship in the nature of marriage, which means for the first time, the Protection of Women from Domestic Violence Act of 2005 considered the realistic situation in the society that there could be relationships where they are not legally married, or a couple may not be legally married. They may not be husband and wife in the eyes of law. There may not be legal sanctity to that. Sorry. But they still live together, say 5 years, 10 years, that is why the words which are used are relationship in the nature of marriage. And I would like to go a little more on this. So for the first time, a live-in relationship was also sort of considered and recognized by the court. That though it has no legal standing in that sense of the word, because there's no legal status offered to those people, nonetheless, it is a relationship, and these are the things that are happening. Now, the question that arises for us is to understand is what is a relationship in the nature of marriage? I am married. I'm giving you an example. I'm married. I'm unhappy in my marriage. I go and fall in love with a man, and I live with him. Okay? He may be single, he may be married. Now, I'm having a live-in relationship with him because I'm, say, 5 years, 6 years, I've not done anything about it, and I'm living. Tomorrow, if that man and me do have a problem, does the law recognize me as being in a shared household? Does the law recognize me to be in a situation where we are in a relationship which is in the nature of marriage? The answer is no. And this situation has been analyzed by the Supreme Court in 2 landmark cases. And I'm going to tell you also one of the cases that I personally did, which included this. The case that was laid down was Indira Samra versus V.K.V. Sharma Samra. Sorry, Indira Samra versus V.K.V. Sharma. The judgment was of Justice Radhakrishnan and Justice Pinaki Ghosh, and they relied upon the earlier judgment of the Supreme Court. As I'm taking both of them together, which was D. Veluswamy versus D. Pachaimal, 2010 10 Supreme Court cases 469. Now, these 2 cases I'm taking together. First, the Veluswamy case came, which was in 2010, and then came the Indira Samra case, which was there. Now, in both these cases, what was laid down was that a live-in relationship has to be in the nature of marriage, which means, suppose if these 2 people wanted to get married, they were having a live-in relationship, but they wanted to get married, they would be in a legal position, in a legal capacity to get married. Okay? This is held, which is akin to a common law of marriage, which inter alia requires A, that the parties must have voluntarily cohabited. Number 2, so nobody is held in, with a lot of force, etc. Number 2, they have held themselves out to the world as being akin to spouses. You have a neighbor where there's a man and a woman. They are residing, okay? For 5 years, 6 years, whatever, they've come as tenants or they've bought the apartment. I don't think anybody is going to ask them, listen, are you guys married? Are you husband and wife? You presume. So that is why the words that have been used is that they should hold out to the world as being akin to spouses for a significant period of time. Number 3, the parties to have shared households. Merely spending weekends or one night together does not constitute domestic relationship. And lastly, not all live-in relationships form a relationship in the nature of marriage, since several parameters have to be fulfilled. So in this case, the courts refused to recognize the relationship, both the cases of Veluswamy and Indira Samra, to be a live-in relationship. Now, I'll share an example. Some of you may be aware of a matter which I did, which was of a very well-known Bollywood star, but I was representing the woman who at that point of time claimed to be in a living relationship with him during the time that he was alive. The man was married, a superstar, had children, wife. However, whatever the issues were, the wife and the children were living separately for a number of years, 10 years, 15 years, whatever, a long period of time. During this period, but there was no official divorce, there was no official separation, no other agreement. During this period, this lady got into contact with this gentleman, the superstar, and they started having a living relationship. They lived together for 1 year, 2 years, 3 years, because by which time he had become pretty old and he was not keeping well, but they were living together. That's okay. And then, while they were living together, she realized that considering that this man is getting old and whatever the case may be, his wife and children who have now started coming to the house, meeting him, spending time with him, and as a result of which he was behaving with her in a very cussed manner and treating her very badly. So during the time that he was there, she sent a legal notice to him saying uh, that me and you have been into a living relationship and that I need to be exact as asking for maintenance because you've not been treating well, etc. It's been domestic violence on me, financial violence, emotional violence on me, and that is why you should be paying. Unfortunately, when the legal notice was sent, the person died. Then his legal heirs came on record. And when his legal heirs came on record, and she filed a petition here in the Bombay Metropolitan Magistrates Court, the magistrate here, the honorable judge, issued notice to the heirs of the deceased, who were also superstars. And since that notice was issued to the heirs of the to take care of the woman, because according to the honorable court, that she had spent whatever 2-3 years of her life in the evening of his life, looking after him, taking care of him, and they were having a relationship. The notice was challenged by the heirs of the superstar, saying that this is not the domestic violence petition cannot survive because of whatever it is. That notice was challenged and it came to the High Court, and I appeared for the lady who was there, and we tried to bring about that this is what the whole situation is. The courts relied heavily on the judgments which I have read out, and they said that this superstar may have been separated from his wife for say 10 years, 15 years, but they were still, in the eyes of law, husband and wife. And as a result of which, he could not have validly, legally, even under the DV Act, been in a relationship of domestic in nature, though you may be living in the same household. Because if you all had decided to get married to each other, hypothetically, if they decided to get married to each other, they could not have got married to each other since he continued to be a married man, though she was a single woman, which is there. And on the basis of that, that petition of domestic violence was rejected. And the notice which was there, of course, it's gone in the Supreme Court now, and that matter is pending as we speak. It's in a way sub judice. What I was trying to bring this particular thing was to your notice was to emphasize upon what is a valid live-in relationship as compared to the otherwise, which is what the courts have laid down. Similarly, you have seen in the Domestic Violence Act, there are various provisions which are there. Now, what are the important provisions which are there? Number one, there is a residence provision, which is under Section 19 of the Act. And there are monetary. I'm just dealing with the monetary aspect of the DV, not the other aspects of it, because our thing is area focused. Section 19 of the Act talks about the residence order. It says that if there's an application which is made, then the courts may, the applicant may ask for residence orders pending the petition and the final hearing of it, and or directing the respondent to secure the same level of alternate accommodation for the aggrieved person as enjoyed by her in the shared household, or to pay the rent for the same if the circumstances so require. So, under the DV Act, in a legally acceptable live-in relationship, also the applicant can seek alternate residence in the event she's thrown out of the house. As you know, this this law is only for the women, for the protection of women. If the woman is thrown out of the house, she has a right, and she has no residence of her own or things which are there, then she has a right to go to the courts and make a plea to the court that residence orders be granted. Either you ask the man, in this case, whether he's a husband or a live-in partner, to get out of the house so that I'm protected because there's domestic violence on me. Or if that's not possible, then he should give me alternate accommodation or rental or whatever the case may be. So this is the provision which is also there under the Domestic Violence Act to protect the rights of the residents of the woman, aggrieved woman, who is probably caught into a domestic abusive relationship which is there. In fact, since I'm on this topic, I would deviate a little bit, but this is very relevant. In fact, just yesterday I was on a webinar and I was addressing the same issue, that there has been a rise during this pandemic and the lockdown. At least I'm talking about the urban metros. I'm truly not aware what happens at taluka level and at the district level. There is an increase in the number of cases of domestic violence which is happening. Partners or couples are locked in the house because of the lockdown. They are unable to go out. It creates, they don't have their own space. So these are seen, there are a lot of psychological reasons also for this domestic abuse. Two people who were residing in one place, the husband was going for the man was going for work, the wife is going for work, and they were coming back and they could do. But now this lockdown for the last 4 months has just put them across each other, and that created a lot of issues. So there was a lot of mental violence that was perpetrated on the wife. Some of the wives called me up and said that there was financial violence, would not give me money to go and buy stuff which is there, or would just, if the air conditioner was not working, then just not get it repaired, just not do. So some things which are there to cause nuisance to the wife, which is there. And in some cases also where it was there, that there was actual physical violence, and a lot of cases where there was sexual violence. So in this pandemic and in this lockdown, this new, as they call it, a parallel pandemic or a shadow pandemic came out, wherein these people who were trapped in the abusive relationship within the four walls, and the police, as you know, were absolutely, they were overburdened with treating COVID and the COVID situation that was around. And even if they were wanting to help and wanting to do that, they themselves lacked the infrastructure. And that's why there were domestic violence helplines, and there were other NGOs which were working. So coming back to this, what happens is that these are the provisions which are there in law. And these are the provisions which the courts have enhanced, expanded, interpreted, so that there is justice which is done as far as the cases are concerned. However, the courts till date have categorically held that a woman cannot have a right in the in-laws' properties. The famous case law we all know, and I think all of us who practicing matrimonial law or this kind of law know about S.P. Batra versus Taruna Batra. This was Justice Kajju's a classic example, which is still being going there, that it is not the duty of the in-laws to provide precedence, but it is the duty of the husband which is there. And there is also the judgment of Vimlaben Patel versus Vatsalaben Patel, 2008 for SCC 649. And it said that when it comes to the maintenance of the wife under the DV Act, read along with the Hindu Marriage Act, it is the personal obligation of the husband to maintain his wife, and the property of the mother-in-law cannot be a subject matter. So the essential part is that if the husband has a right in that asset, if there is an undivided share that he has, or there's a part of it that stays in his, it is a part of the house is in his name, then only then under such circumstances, the wife who is applying under the Domestic Violence Act can ask for any relief. We have also seen another type of cases which comes up, and I'm sure a lot of you as lawyers come up. What happens in those cases where the house stands in the joint name, and I'm talking about this alimony part of it. The house stands in the joint names of the husband and the wife. Suppose the house has been bought, say, for 1 crore. The husband has paid the initial amount, and he continues to pay the EMI, but he has taken the joint names of the wife and the husband. Joint names. The society records are also showing the same. Registration is also. We find many cases that when the dispute arises and the divorce happens, the wife claims 50% of that, saying that I'm a joint owner. So the value of the house is 1 crore, I should be granted 50 lakhs towards my receipt. And the husband says that she has not she has not contributed anything. Now, if you see under the Transfer of Property Act, if there are two people, if you and me are friends and we buy jointly a property, the courts will decide the percentage of what we have invested in the purchase of that property. It could be 20%, 40%, as the case may be. Now, in this case, the wife has not contributed anything. But she says that I'm a joint owner, I should get. Is she right? Yes, because the house stands in her name. She has not contributed, so does she have a right in that house, whether 50% or otherwise? The answer is that percentage can be decided by the court. But if it is in the joint name and she's been living in that house, obviously there is some claim that she can make because A, it is in her name. She can also make a claim if the house is not in her name jointly, but is solely in the husband's name, because she has a right from the property that comes or belongs to the husband and not which belongs to either the in-laws, as the case is. So these are the finer nuances which I have tried to sort of capture in this, how do I say, in this webinar. Now, Priyanka, how much of a time? I think I've already overshot, right? My time. Priyanka?
Ma'am, you can go on. It's absolutely no issue.
So can I speak on the child custody, or would you
Yes.
want what I was thinking, of course, subject to what you feel. What I was thinking was that if you want, we could just do maintenance now, because it's been over an hour and 15 minutes, and take questions on that, because child custody itself is a very, very, it's a very, wide thing, because there's Guardians and Wards Act, there is the provisions under the Minority Guardianship Act, there are provisions which I would like to cover, and there are provisions under Section 26 of the Hindu Marriage Act, and also a lot of questions, a lot of case law, where today we find, at least in the metros or even with these NRI marriages happening, cross-border custody issues which are there. So if you let me know how you want me to go about it, I'm fine either which way. But then this is a special thing. My suggestion is, I don't know, you please take a call with all your people.
Yes, ma'am. We'll do whatever you suggest, ma'am. So we'll concentrate.
So let us do one thing. Yeah, let us do one thing. Now that I've covered maintenance, let me take questions from the lawyers, because that would be more interactive. And time permitting, then we'll see what it is. Otherwise, I'm happy if you want me to come back again to speak on the child custody issues also. I'm happy to do that, depending on how you want it.
Yes, ma'am. We would love to have you again with the child custody issues, because there are a lot of questions that have been pouring in from all over India, I would say, not only Maharashtra. So we'll, ma'am, I'd like to invite you again for the child custody topic. Right now, we'll concentrate only on the maintenance perspective.
I think so. Yes. Can we throw open the floor for the questions from the participants?
Yeah. Over to Sheetal Babar, ma'am, for the question answer session. Over to you, ma'am.
Yes. Thank you, Priyanka, ma'am. Ma'am, this was such a stupendous session, I must say. I, being a family law teacher in a college, I guess I had few questions in my mind which have been already cleared by what all you have said. But then our audience do have few questions. Let me start with the first one. This is Advocate Kamini Ahuja, who's a solicitor as well. She's asked a question. Often husbands fail or neglect to pay maintenance after some time. Is the wife entitled to ask for a financial security to ensure her maintenance amount, such as a bank guarantee or a fixed deposit?
So a maintenance order, as we all know, has to be complied by the husband. But sometimes the fear is there. For example, I'll tell you why go far off. See, in today's times of COVID, so many of them have lost their jobs. Let's look at the realistic thing, then I'll come to that answer. So many of and there's a maintenance order which is running against the husband. So many of them have lost their job. So many of them have been given a cut in their pay, where there is 30% which is deducted or 40% which is deducted. Even the Air India pilots, 40% their salaries have been deducted. I'm giving you an example. So these are the things which are there. Now, under such circumstances, what is it that the courts are going to say? Are the courts going to say that no, you have to clear the maintenance arrears, etc., which are there, because she also needs to survive and she also needs to lead a life of dignity? Or are the courts going to say that no, the situation is a little difficult right now and we need to consider these things? So this is something which are the new problems, which I just thought, since she brought out a very interesting and a relevant question. that these are the new issues that are coming up during this pandemic. And the courts are really caught between, as they say, the devil and the deep blue, not knowing what to do. They want to be fair to the husband. They want to also protect the wife because she has a maintenance order. But how does one work around? Now, coming back to the question that Kamini has asked about it. Yes, there are provisions where you can have a charge on the property, or you could have certain things which are there. But again, as I said, this all depends on the facts and circumstances of the case. It also depends upon how the court views this entire thing. The insecurity of a woman who is getting a per month maintenance as per the orders of the court is always high as compared to a person who has got a lump sum. So, Kamini, I can tell you that when clients come to me, and suppose there's a lady client and I'm negotiating with the other side lawyer about the settlement which is there, I obviously, as a woman's lawyer, I would want to have a lump sum amount which is there. I always tell my, and this I'm sharing my personal thing, I always tell my lady clients that it is better that you take a cut of 10-20% less, but get a lump sum amount which is in your name as a part of a divorce settlement, rather than go for a per month thing, because situations change, circumstances change, and you may be today it may be a comfortable situation, but tomorrow it may not be so comfortable for you, and as a result of which the husband may, God forbid, what happens, the husband becomes incapacitated. Then there is a change of circumstances. The husband can go to the court and say, there's a maintenance order of 1 lakh rupees given to the court, but I'm now incapacitated because of physical illness, mental illness, which is there, or the pandemic right now, what we're talking about. So this then the lady is at the mercy of the situation which is arising. So it is always better to have this. But to answer your question, surely a bank guarantee or a charge on some property can always be negotiated if you are, sort of drawing up terms of mutual consent.
Thank you, ma'am. Truly quoted the thing quite easily and understandable way, ma'am. Thank you so much, ma'am. We have another lady who's asking a question wherein she asks us, how can a petitioner wife prevent a respondent husband from disposing or selling or rather transferring his properties during pendency of divorce case to avoid prejudice to wives and children's right?
Oh, this is it's a very simple thing, that pending litigation, if a husband has properties, then the wife can go to the court and say, seeking an injunction from the court, restraining him, his servants, agents, etc., that pending these proceedings to be restrained from either creating any third party rights in terms of giving a gift deed or creating a transfer deed, or selling it or doing any of those things which are there, because her rights of maintenance alimony are still to be decided by the court, and this should form a part of the corpus to be able to decide that. In 9 out of 10, I would say, would give such an order if, only if, the property belongs to the husband. Now, the question that sometimes, or the difficulty, let me just go ahead a little bit. The difficulty that arises is what happens if the property is in the joint name, the joint names of the husband and, say, his mother. Can you get an order like this? The mother is not a party to the suit. The mother is not a party to your issues which are there. Now, whether you can get such an order, for that order, you may have to go under the shared household, under the Domestic Violence Act, so that you can get an order that you are not deprived of what is your legitimate claims or the dues which are there, and that's how they will be able to protect you. But we as lawyers do find a difficulty, because the husband may say that, okay, you can restrain me 50%, but then I cannot say anything about the wife, about my mother, who is the 50% owner of the property. So, but even if you are able to get an order that the husband cannot do, and mostly, and in all joint properties, all transactions have to be done jointly. If he is restrained by an order of the court not to get into this transaction because the rights of the wife and the child are at stake or subjugated, then that will, in a way, indirectly even bind the mother-in-law for not selling or disposing of that property. Tomorrow she can go independent. Sorry to say, I'll just take 1 minute more. The mother-in-law can go to a civil court and stake an independent claim that I need that house, or I need to sell that house, or I need that money. And these are the claims. And so then that gets into a parallel litigation, which would be in the civil courts, where she might want to contest that order, though she knows that it cannot. So the order can only be passed against the husband and surely not against the mother.
Perfectly quoted, ma'am. The real life situations, I would say, where it's a joint property
Correct.
in between.
Correct.
This perfect question also was asked by Miss Aarti Chilakwad, ma'am. We come on to the second question, third question of the session, wherein Abhijit Gosavi wants to ask you, if a property is transferred by husband in the name of parent just before filing the case, would wife claim the same? Or does she has any rights to claim the same?
So before I answer Abhijit's question, most of the people, on the advice of the lawyers, and let me be honest to you, when they see that there is trouble brewing in their marriage, and when they see that such things are happening, and tomorrow if the matters do go to the court, the husband's assets will be considered, do either on legal advice or on their own, whoever their chartered accountant or their person is advised, they do transfer it. Now, the question that arises is that suppose the petition is filed in 2019 and this transfer has been done in 2018. If the wife in her petition or in her claim shows that there have been issues between them right from the time of 2016, by which time the house was in the husband's name, and then when it got accelerated and when it got heightened, that is the time he has done because he knew I would go to the court or he wanted to go to the court. And this has been done in a deliberate manner to deprive me of my dues and my legal rights. Then under such circumstances, the courts could consider, again, as I said, it's a very subjective view of the court. And I cannot give you that, okay, this is what it is. The courts could consider that the act of the husband in transferring the house or property, which was in his name, was gifted to his parents even prior to the start of the litigation. But during the time when the trouble was brewing, they would consider it to be a part of his property, though the document may not exactly be on his name due to the transfer or the gift that has taken place. That's the way.
Rightly stated, ma'am. We have another question from Advocate Sylvan DeCosta, who asks the question, does maintenance includes house or a flat or shelter? And if yes, does it contributes to lessening the alimony amount?
So ultimately, when I started my lecture, I told you that this term of maintenance is more sort of defined and expanded better under the Hindu Adoption Maintenance Act in the definition column, which is there, which is what the courts borrow even when they are deciding petitions under the Hindu Marriage Act or for the maintenance and the alimony, which is there. Maintenance includes residence, maintenance includes living expenses, it also includes medical expenses, and it also includes what are known as the education expenses. So if residence, education, medical, which is there, then obviously the amount that you're going to get as alimony, if you're given a residence order, has to come down, right? Because they cannot give you 100 rupees for your residence and plus 500 rupees for your alimony if the husband does not have the capacity. See, ultimately, please understand one thing. Maintenance laws are not to penalize anybody or not to just empower and enrich somebody in an unjust manner. The maintenance laws are done in a very equitable manner by the courts. Most of the courts look at it from an equitable point of view, where in most cases where the wife is at the receiving end because she has no money or because she has kids or because she has no wherewithal to maintain herself, that she is taken care of. But it doesn't mean that the husband is penalized or he is it's a punishment for him to be given so that he also leads a life of, that he has to survive on bare minimum and he has to dole out a reasonable or lump sum amount to the wife because that's a court's order. The courts are going to strike a balance in coming to the amount which is.
Absolutely agree, ma'am. With your kind permission, let me just have few more questions, ma'am.
Yes, please.
There is this Narendra Ramnani who asks the question, order of maintenance upheld up to Supreme Court, order of sentence passed in recovery applications, still the husband not traceable with the help of his family and local police. What do wife do who is from a different state? So I guess, ma'am, he basically.
I'm not too clear about the question. I think what I understand is some order of maintenance has been upheld right up to
Yes.
Supreme Court.
Yes, ma'am. He seems.
Yeah, and I think what I've understood from you is right up to the Supreme Court. However, the difficulty that the wife is facing is how does she execute that order, because she does not have his whereabouts, or she doesn't know where his
Correct.
family is.
Correct, ma'am.
But I'll tell you something which is I would not say very common, but it's quite a task and a challenge for such women. So I always say in all my lectures that getting orders is the easier part of it. The executing of that order is the most difficult part of it, because we have seen that people, in most cases, I don't want to generalize it, but in most cases, people find ways and means of not complying with the order for some reason or the other. And that is why you have to make a recovery application, the attachment of salary, or attachment of the assets, or in some cases, even imprisonment, whatever the proceedings are there under the CPC. So this is where the struggle the wife does have to sort of face it. So this is true, but then, I mean, at best, she can just rely upon the court's orders, even if it means arrest. But the question here is that she's not aware of the whereabouts. Maybe, I don't know, but maybe a habeas corpus about him for the cops to find out where he is because she wants to execute the order. Maybe that's one remedy that she can explore, but I'm not too sure what would be the correct way to go about it.
Perfect, ma'am. Absolutely agree with whatever you said, depending on the circumstances of each case. Probably it all depends.
Right.
I would like to go with the second last question of today's session. This question is by Advocate Ajit Pawar, who asks, what can a husband do in case the wife doesn't want to stay with him, not willing to divorce as well, nor seeking any alimony, and just intends to drag the matter?
Absolutely. There are some women who can really make the life of their husbands a living hell. And I'm not surprised by this question. It's more of like a dog in a manger attitude. I won't divorce you. I don't want your money, but I will not let you live your life. So the only so I can just tell you one of the cases that I did, and I think it's become really, in that sense, it's not a case of a celebrity, but it's become a landmark, that the husband filed, and I was for the husband in all fairness, in the lower court in the year 1999, okay? And lower court rejected his petition, saying that no, you've not been able to prove mental cruelty against your wife. We went to the High Court against the lower court's order. The High Court also upheld the lower court. They said, no, there was no cruelty. There's some variation in the alimony, etc. And again, he went to the High Court and, Supreme Court against the High Court order. And the SLP was also dismissed, saying that no, there was no case and we are not going to even admit your petition, which is there. So this was a case of a doctor who has been separated from his wife as we speak today for the last 20 years. He is complying with the orders of the maintenance which is to be given to her. The child who was earlier with the wife, and for whom also he was paying, while the child was studying in the 11th standard or 10th standard, chose to come and be with his father because he wants to be a doctor and he wants to be with the father. So the child is also with him. And today, for last 20 years, he has not got a divorce because the wife is not willing to give him a divorce. The wife is maybe asking for very unreasonable amounts to settle the matter. And thirdly, and more importantly, the courts have considered that there is no mental cruelty in this case, so we can't grant a divorce. What does such a man do? So there are these certain cases which are there. I'm not denying that doesn't happen. But nowadays, I feel some of the courts proactively in such cases where there's a long separation and there are, because we don't, I tell you, one of the reasons is, of course, this is not a lecture for grounds of divorce or marriages. But one of the reasons that we don't have it is because we don't have an irretrievable breakdown of marriage as one of the grounds for divorce. You have to prove cruelty, you have to prove desertion, you have to prove adultery, you have to prove mental unsoundness or whatever your case may be. And only then you can get a divorce in the event your wife is not, or the spouse is not agreeing for a divorce. So it becomes a very difficult task. If you see overseas in UK, England, etc., whatever it is, even in a contested petition, you can go for what is known as a no-fault divorce. In the US, it's very popular. I'm the husband and you're the wife, and then and I say there's no fault of the wife, but I just want out from this marriage. I'm not in love anymore, and I'm out of love, and I have to do that. The courts will grant a no fault, but I don't want to say that my wife is bad and she's cruel and she's etc. I'm just out of love and I want to do it. It's a breakdown of my marriage. The courts will grant him divorce and then decide the amount of alimony, child support, etc., whatever they want, depending on which state they belong to, because in the US, the federal laws are different in every state. They also have what is known as an irritable breakdown of marriage, which also the courts do. But here, if I go to the court and I say that for the last 15 years, I'm not staying with my husband, or whatever the case may be, and then this itself is a glaring example that my marriage has broken down, and there is no sort of, there's no, because the wife in that case, which I said, which we lost right up to the Supreme Court, where the wife is not even, she did not even make any claim of restitution. She did not even say that I want to live with my husband. I mean, I could have understood that claim also, that, okay, there could be some women who want to live with their husband, or they want the marriage which is there. None of those claims were there. We argued to the best of my ability and everything which was there, but the court said, no, you not prove mental cruelty. You have to prove mental cruelty during the period of your cohabitation. Don't tell us how she has behaved, everything afterward. That is not, we are not going to consider. Anyway, that's an individual judgment, and it depends on the facts. So I'm not going into the details of the judgment. But in this case also, yes, there are such cases that do happen. And it's unfortunate, but that's how the laws are. And that is why I can share with you that, because I was a part of it, that we have made recommendations to the Law Commission to introduce that as a ground for divorce if the courts feel that there is sufficient number of years of separation, and if they examine and find out that there's no future for this and it's broken down completely, then they may consider as a ground. But then still, that's still at the Law Commission stage. It's not the law, so I don't think I should be speaking about it. But yes, these are the difficulties that people do face on several things. Because what happens is that you have a concept of mutual consent, where you have 1 year of marriage and 1 year of separation. You can go, both of you do it. That is the most decent and the graceful way of doing it. But there could be difficult partners that some people do have, and that's where they face this kind of a difficulty.
Absolutely, ma'am. I must say the saddest reality where, especially in our country, we say marriage is a sacrament, but still there's spouses who face these kind of unfortunate incidences. Ma'am, I would like to take you to the last question of the session, where Advocate Vipula Lenghar asks a question. Maintenance is remedy available under Hindu Marriage Act, Section 24. Also under Section 20 of Domestic Violence Act 2005, as well as Section 125 CRPC. Is there any difference in between all these? And are there any specific occasions when we can approach them similarly at the same occasions, or are all of these means the same?
So as the present laws are, that a woman can apply under, suppose there's a pending petition under Section 24, she can apply. So there are cases where women apply under Section 24. They can apply, if the husband has filed for divorce, they can apply under Section 18 of the Hindu Adoption Maintenance Act, asking for any of the interim relief. They can ask under the Domestic Violence Act for the residence or maintenance, which is there. And these all could be either in one court, or they could be in the different forums which are there. One could be in the family court, one could be in the criminal courts, and so on and so forth. So nothing stops a woman from approaching all these things. But obviously, when the courts are going to pass an order, they are going to consider if there is any previously passed order of any other court under any other provision. For example, a sum of ₹100 has been granted under Section 24 after going into the details of their income, lifestyle, and etc., which is there. And again, she goes and says, I again want an X amount under the DD. I again want a Y amount under 125. So there should not be something what is called as a double jeopardy. where the husband cannot be taxed at every stage, or taxed in a sense in terms of money. He cannot be taxed at every stage and things which are there, because if his income is considered to be an X amount, the courts will have to decide within that X amount under what provision that the person should get. For example, a compensation order for the domestic violence, the courts will only grant if the woman is able to justify to the court that she was subjected to domestic violence, and she's proved it to the court, and court says, yes, yes, of course you have done that, we grant you that compensation. It could also happen sometimes, and this could overlap, or that could be also considered, but most of the time the courts do consider. Because as I said, the orders of the court are to look to find a balance between the husband and the wife, and the orders have to be equitable. So if compensation orders are passed in a domestic violence proceeding, then what would the courts do as far as the alimony is concerned? Would they also go according to their own laws of alimony which are laid down, or the judgments or the precedents which are there? Or will they also consider that under the Domestic Violence Act, an X amount has been granted towards the compensation? This all depends on individual facts and circumstances of the case, the subjective views of the court, and what the courts. But normally, I would expect the courts to consider whatever the other courts' orders are there to be taken into consideration, and they do it also whilst granting any amount under the application which they are deciding.
Thank you so much, ma'am. This was all from the audience side. They had these queries, and I suppose as no more queries, that means it was everything clear to the audience from your side. Ma'am, with all the apologies, if there was any inappropriateness from my side, I just want to confess in front of everyone that this was absolute privilege to have interaction with you. I thank you, ma'am, and I hand over this session to Professor Deepa Vagyani. Thank you so much, ma'am.
Thank you. Thank you so much.
Thank you, Sheetal. Good evening, ma'am. Thank you so much for the wonderful, insightful lecture on the very important topic from family law. We felt privileged to hear you. This is Professor Deepa Vagyani to express gratitude on behalf of Advocate Vasantrao Patil Lawyers Training Center. I want to thank Sangli Bar Association for providing us this platform. I want to thank the coordinating committee, the conveyor committee, for having this webinar. I would like to thank the technical team of Advocate Vasantrao Patil Lawyers Training Center for this, for the smooth running of this program. Plus, I would like to thank all the lawyers and advocates and the law students who participated here today. Ma'am, just to mention, we had a theme of pink webinar today with a woman speaker and all women panelists.
Wow.
So we are just delighted to have you today, and I feel just honored to have you today. Plus, I would like to mention that the chat box has been flooded with the positive comments. So we want you again back on the same platform with yet another topic, and I believe you will be agreeing for that. Plus, I would like to thank ma'am to you for the sharing of the Sunday evening with us. Even today is the International Parents' Day. I must say that our Parents' Day has been duly celebrated in your company. With that positive note, I would like to seek your permission to conclude this webinar. Shall we?
Yeah, thank you so much. May I just take a minute of yours, Priyanka, and the entire the women power that we have here. I think today is a very unique day, calling it a pink day and talking about all the laws that empower women. And I see such wonderful, accomplished women on the panel here. I'm also absolutely delighted to be a part of this evening. And my apologies, I could not conclude both the topics in this. Priyanka had told me that I have to speak on custody, but I thought I never like to do something half-hearted. I didn't just want to hurry up the maintenance part because I had to sort of, adjust the custody. So to be fair, I thought, let me just concentrate on one so that we are able to do that. It will be my delight and pleasure, if you feel appropriate, to invite me again to share my views on the laws of custody, more particularly at the Hindu Minority Guardianship Act and Guardians and Wards Act and other relevant provisions, because that's also a very important segment of the family law which we need to sort of, understand, analyze, and think about it. But thank you so much for making me a part of this beautiful evening. Thank you very much.
Ma'am, we would like to have you here again and again. And the topics are endless. And it was absolutely a delight to hear you, ma'am. So a heartfelt thank from my side and from Sangli Bar Association and on behalf of Vasantrao Patil's Lawyer Training Center.
Thank you so much. Thank you for inviting me. And I'll be happy to, if time permits all of us, to address on the issues of child custody also.
Yes, ma'am.
Thank you. Thank you so much.
Thank you.